Good morning, everybody. It's a small group, so I think we can be very interactive. So just please drop in when you have the feeling that you need a deeper information or something more explained. The first, I have two questions which I would like to raise in order to understand who you are. The first is, it will be a presentation about legal cases. So who has legal background in here?
What do you define as legal background?
Well, has a knowledge about the PSI directive and the whereabouts of all these items that are now in the European discussion? One, little? So, not too much. And who is from public sector or public administration? Okay. Thank you. So I have to watch out what to say. Well, first about myself. My name is Nikolaus Futter. Thank you for the introduction. And I'm managing director of a publishing company in Austria called Compass. We are publishing directories, which is business information. And on the other hand, in my second role, or one of my other roles, I'm chairman of the PSI Alliance here in Brussels. PSI Alliance was founded 6 years ago in order to have an industry body representing the industry in Europe that is reusing public sector information and to have a body that is on the other side of the European Commission and the policymakers. But I was asked here for today to present the legal cases we had, so the real life experience that was a nightmare for us for the last 13 years. So we're talking about a legal case that was going for 13 years. Well, briefly about us, meaning the company. This is a reprint of our first book. It was published for the year 1868. So it was published actually at the end of 67. Let me pass it around. There's a brief information, a brief idea what we have been doing over the last 145 years, 47 years. Hi, Christian. So we have been publishing business information continuously since 1868 and have been reuse of public sector information since then. Because if you publish about companies, then you publish information that is registered somewhere and that is based on legal grounds. We managed to struggle through 2 world wars, survived the reduction of Austria to a small country, and finally in 1997, so after 130 years, we decided proactively to leave the printed world and go into electronics. So this is the legal grounds on company registration from 1863. So in 1868 we started with all of it. And this is an edition of our book in the war times. And you may notice this label up there. It was declared state secret. And actually I have in my archives an edition, a photography, not a photocopy, photography, of the US Secret Services where they identified targets for bombing and things like that. So business information is of high value to an economy in all good and bad times. And so since 2003 we are electronic only, so we're just publishing our information electronically. So what do we do, what did we do during the years? We reused public sector information. which was the register of companies, commercial register, Handelsregister, Firmenbuch as it is called nowadays. And the data, so a data set out of this register is under the paragraph 7 of the Austrian Copyright Act, which is that public information is free. So, fine, so far. We did it since, as I said, since 1862, when the commercial law was introduced in Austria. It is important to know that, of course, any legal entity, any company, only is constituted through a legal act and through an entry into the register. Without the entry into the register, it's not a company. It's nothing. It's just an undertaking of a person that's not registered anywhere. So the commercial register, the register of companies, actually is the basis for all publishing and information activities through business information providers as us, or credit reporting agencies, and whatever you find in this information environment. So, a brief background to what happened to us. And now it gets legal. So if you have the feeling not to understand what I'm talking about, please just raise your hand and I'll explain it more deeper, or in maybe other words or whatever. So just to find the right approach. Actually, already in 1984, so it's now 30 years ago, we started building a database based on the excerpts from the trade register, and built a database out of the official publication on the changes and entries into the register. The Ministry of Justice, that is in charge of all this, started developing an electronic version. Up to then it was an archive version in the ministry's office, and you had to go there, and it was written into a big book and things like that. In 1990, the ministry started an initiative to electronicize all these proceedings, all these whereabouts, and introduced the electronic, then Firmenbuch, before it was the Handelsregister, commercial register, now company's book, as you might call it. And we bought, of course, this information. It was then made publicly available through video text service until 99, and from 99 on it was available through internet and still is. So it was publicly available. You had to pay a fee for every excerpt, which was quite a lot of money that we had to pay over the time. And we bought all this information in the good feeling that this information would be free anyway, because the data is free. But, and now it gets complicated. In 1998, the Directive on the Legal Protection of Database was transposed to the national law and entered into force in the Austrian Copyright Act. Does anybody know what the legal protection of databases means? Christian, I know. So, it's about that databases are protected because you have an effort to build a database. It's not just the contents, it's the effort that you put in the database, so that therefore it is protected. And actually, just a year later, or a year and a half later, the Ministry of Justice had a bright idea. They adopted a bylaw, legal regulation, that said that their database would from now on be protected, and reuse would not be allowed anymore. It was permitted to reuse the database. So, not so easy when you use the data every day and you have to rely to build your products on this data. So, they monitored us, And after 3 years, I said now before we can protect our interests anymore, 3 years is the time of losing your protection, they brought an action against us in 2001. And 2001, we have now 2014, the case ended this year in February. And they brought actually an protective procedure and they sought immediate action against us in order to prevent us from reusing the database and the data content of it. You know, it's a fast case, seeking immediate action, and to have a protective procedure. So the courts really are doing it very, very fast. They have very short periods to answer and so forth and so forth. And luckily for us, the first 2 instances, so first court, second court, just dismissed the whole case. They simply said the Republic of Austria is nuts. So this, of course, meant a problem to the Ministry of Justice. The Ministry of Justice, who is, you know, the employer of the judges, because they are part of the legal system, now had the problem that their case in protecting their own interests was dismissed by the legal system they were, you know, the heads of. So, what to do? They asked a judge of the Austrian High Court, who is specialized in copyright law, to write a nice article, and he wrote a nice article. And the article said that, of course, the public sector has a right to protect its own databases, and so forth and so forth. It was the single opinion in many different opinions that were out there. And finally, the Austrian High Court then had, luckily, the decision that they could now protect the database because there was this significant voice in an article saying that the database can be protected. We had also the argument that it's not only copyright, and this database should not only be free from copyright. One of our arguments also was that this is a matter of competition, because if this is a sole source information and you have no other information to represent the company if you want to describe it, because it's by law that only the entry in the register constitutes the company. So we also had the arguments based on the essential facilities doctrine that was developed by the European Court of Justice over the years, which actually was introduced to prevent monopolies in infrastructure, like gas pipes, water pipes, electricity wires, and things like that. But the Austrian High Court said, yes, okay. On the one hand, the database is protected by copyright according to the Database Protection Directive. But on the other hand, you can't disclose a company that is relying its business on that from reusing the data. So we were allowed to reuse the data, but the database is protected by copyright. And we were allowed to reuse the data only if we paid an adequate price. What's an adequate price? Not that easy to discuss because the public sector has a completely different opinion what an adequate price would be versus a private entity. So after this immediate action, the main case, the main proceedings went through until Austrian High Court again and ended in 2007, confirming the decision of the immediate action that was sought against us. So from 2007 on, the database was protected under the Austrian copyright law, and we were allowed to reuse the data, paying an adequate price. Still, in 2007, we had no idea what an adequate price would be. So there were a couple of very interesting inconsistencies in these proceedings. First, the ministry just sued us, not any other company reusing the data. Because most companies reusing the data were credit bureaus, credit information companies. And the minister said, off record, well, this is of public interest, credit information is of public interest, and your business is not of public interest. Bad luck. Not very supportive. They had adopted a bylaw saying that the database was protected, but sued us based on private law. So it was public law, which constituted the protection, and private law executing it. We were threatened to go out of business. The action they thought was stop this company, which was not very nice. And they denied, in the immediate action case, they denied to go to the European Court of Justice. We called for a preliminary ruling from the European Court of Justice. Sorry. How the sui generis database rights, database protection idea, has to be executed on an official database. A database that is not constructed by somebody working on it, but is constructed by law and organizational measures of the public sector. And the reason for that was the argument, we can't do a preliminary proceeding by the European Court of Justice in an immediate action case because it has to go fast, because the Republic of Austria is seeking its protection. So we can't go to the European Court of Justice because it will take another year or another 2 years to get the decision there. And the question was that we raised against the European Court of Justice, is the sui generis database right applicable to a public database? Because according to the Database Protection Directive, it has 3 reasons that have to work together to protect the database. There has to be an investment. This is the most important reason. But there are 2 other reasons that are unluckily only in the recitals. They are not in the articles. One is risk, the other one is initiative. So the idea of the European lawmakers was to protect an economic undertaking of building a database. The argument of the Republic was, we had an investment, yes, I mean building a database costs money. But they had the initiative because the parliament passed a law, and they had a risk because it could have failed. So building an administrative database in the Republic of Austria could have failed. Okay? Anyhow, the court, or the Austrian High Court, decided only on the argument of the investment, not at all including any of the other arguments. What's the time? Oh. How many? 20 minutes, okay. So, funnily enough, vice versa, in the main proceedings, we again asked, please ask the European Court of Justice whether a public database can be protected or not. Then the argument was, the Austrian High Court had already ruled on this, so we don't need the European Court of Justice. So, whichever way you go, you're stuck. So, what happened after the PSI directive went into force? The Minister of Justice sought compensation for the whole period, of course. And they had ideas about what an adequate price would be. So we talked about like 500,000 euros a year plus a revenue share. So according to copyright, they thought it would be nice to have a revenue share because we are misusing their copyright, so they have a grounds, legal grounds to get part of the revenue we did. Of course, the ministry said the PSI directive is not applicable at all because, and here we come into the discussion of the PSI directive, the first directive did not constitute a legal obligation for a public sector body to deliver its data. It was if a public sector body would deliver the data, then the directive would apply. By the way, this sui generis right on databases, the legal protection of databases is part of the regulation in the PSI directive, saying that it is not applicable. So, but the High Court already had decided. Or at least it didn't apply the PSI directive in the national law because it was already in the case going on. They didn't want to introduce a new legal grounds in the whole debate. So at the end, we brought a lawsuit against the Republic based on competition law, saying that we didn't get the data for an adequate payment. It was too much. And we could prove in our case through accounting experts that were called into the discussion from the judge. And the judge had the accounting expert had to investigate the cost side of the data delivery of the Republic of Austria, which was very, very interesting experience. Accounting in an administrative organization, public administrative organization. And he found out that the Republic of Austria is overcharging by more than 100% based on the costs. So looking again into the PSI directive constituted, the first one constituted that a public sector body may recharge for the reuse of the data, and also may charge a certain amount for profit. But 100% is not what was the idea of the European lawmakers when they introduced the PSI directive. So this case, interestingly enough, went up to the European Court of Justice. Why? The question raised was whether the public sector body is acting on public powers when delivering the data from the company register, or whether the delivery of the company registered data is a private contract with us, which of course makes a big difference looking into cartel and competition law. Because if it was a private contract, then of course the competition law and cartel rights would have been applicable. So the European Court of Justice ruled, no, it's not. It's a public task to deliver this data. So this case was dismissed by the Austrian High Court because we can't challenge public task by competition law. But it had an impact on the main case. In the main case, the whole argument, the whole case was based on private law. So if the delivery of the data was public task and therefore public law, then actually the way forward to execute this case and to go into the proceedings would have been completely wrong, because civil law and or private law and public law has completely different ways of legal proceedings. So again, what to do now? The Supreme Court said, what the heck, the European Court of Justice, we don't care. We don't care. It's private law, it's copyright, period. So, the fees were not reduced. The Ministry of Justice insisted on executing the whole case of private law. And this debate ended this year when the Austrian High Court decided against the opinion of the European Court of Justice. We execute the whole case under private law, under copyright law, and Compass has now to pay 1.5700 million, including interest, so a nice sum of 2.4 million. You have to pay this to the Republic of Austria. To give you an estimate what it means for a small company like ours, our turnover in this part of the business is 8 million euros. So about 30% of what our annual turnover is, we now have to pay to the Republic of Austria. So the first 6 months from February until August this year, we worked under legal construction of being insolvent until we found a debt referral agreement with the Republic, which was very long negotiation, very hard to convince them to at least allow us to pay it over the next years. So now we have an annual rate to pay of 400,000 euros, which during the last years was more or less our total profit. And of course, in order to get this agreement, we had to accept a clause that said, whenever we challenge the system again, the total sum is immediately to pay. So we are bound. No way to get out of this. Especially as the European Court of Justice said, it's public law. So why don't we go and say, well, under public law you are not allowed to charge prices like this. We can't do it. Otherwise we would directly go into bankruptcy. So, this is very brief. 13 years condensed into 20 minutes. So, what are the learnings for a private company, private sector company in all this? And I have to stress that this is, of course, an Austrian experience. And I know from other European countries where the whole issues about database protection, copyright of public sector information reuse is fine. Like in Slovenia, for example. They are doing very fine with all. Smart, smooth, everything working well. And please, as most of you are from public sector bodies and are public administrators, please don't feel offended by what the my learnings were from dealing with the public sector. Well, new public management, a big buzzword, but it results in a situation where civil servants see themselves responsible for the income they get through their activities. So they start to act like enterprises, like companies, like entrepreneurs. Actually, the Ministry of Justice calls itself company, Ministry of Justice, Unternehmen Justiz. That's how they call themselves. And if you look into a Ministry of Justice, they have to pay for, all the inmates in the prisons and so forth. So I mean, this is definitely a negative part on their budgets. But actually, they are they're stressing that they are nearly running on profit, the whole jurisdictional system. Nearly running it on profit. PSI holders then have the idea sometimes, we experienced it actually directly, to act and react on private companies, bless you, and to increase their revenue by introducing certain services and products that the private sector is bringing into the market successfully. So, for example, they copied one of our features in our products into the official database, making it possible to get the feature there. It was not a success. I mean, there's no marketing behind it, but anyhow, they did it. They don't see the benefits of public sector information and the reuse of public sector information. It's really the nightmare. They just say, we get money out of our fees, we don't care what's the rest. Also, and this was a very, very strange experience we had, lack of economic expertise and understanding and knowledge. Sales were mixed up with profits by the judges, by our counterparts in the ministries. They can't read balance sheet. When we negotiated this debt referral agreement, and they said, well, you should have known that you will lose the case. We didn't know it until this spring. You should have, especially after the European Court of Justice decision. So you should have known that you will lose the case. So you should have, built accruals on that. So we said, yes, we built accruals. We had 600,000 euros accruals in our balance sheet to, be able to digest this issue. So the question was, so okay then, where are these 600,000 euros? They have to be somewhere. Put them here on the table. If you mix up accruals and cash in your pocket, then you're really out of the economic world at all. I mean, it's just, what are we talking about? They are, at least in Austria, I have to stress this, Austria is very special. They are willing to accept being sued in front of the European Court of Justice before they give in. That's what they told us. You will never, Ministry of Justice. Other ministries are not that bad. They told us, before we give in, you have to sue us in front of the Ministry of the European Court of Justice. And this is something I like most because, of course, during these 13 years, we had lots of negotiations with officials, with cabinet members, with politicians, and so forth and so forth. The civil servants of the Ministry of Justice deliberately and disinform their higher hierarchies. They constantly mix up the issue of excess fees and the issue of reuse fees. So when we're talking about public sector information and the reuse and the PSI directive, our counterparts in politics say, well, if this all comes, we will lose our fees that we gain out of the activities we do. No, we won't. Because the excess fees, and this is in Article 5, I think, of the directive, excess fees are not touched by the directive. So a person seeking the legal information from the register has to pay still a fee. It won't be free under the directive. The only thing is that reuse. So if you want to take the data and reuse it for commercial, non-commercial purposes, then this would be free according to the new directive. Or at marginal costs, as the new directive states it correctly. But marginal costs of the distribution of electronic information usually should be zero. So, one more slide and we're done. No questions in between? Well, the politicians are so much dependent on the administrative level and the public sector bodies that they just let them do what to do. They back them up as long as money flows in. And they also have no long-term perspective. I mean, this is probably everywhere in Europe or everywhere in the world. A politician never thinks more than the next vote or next poll on him. 4 years is maximum in their political agenda and their political vision. And introducing a change of the whole economic system, we will lose on fees, we will lose on direct revenue, but we will increase and develop our economy. And there are studies that prove this. No way to make this understandable to a minister, to a cabinet member, whatever. They just don't care. It's beyond their 4 years perspective. Also, politicians most times lack of economic understanding, especially when they are in Ministry of Economics, Ministry of Finance, Ministry of Infrastructure. And changes only take place when the external pressure grows. So our hope is Europe. Europe is the solution to all this. Through the PSI Alliance, which is my other hat I have, we try to increase the pressure, working together with the European institutions, especially with the Commission. Now we are currently, of course, in the phase of implementation of the new revised directive into national law. It has to be in national law in July 18th next year. And as far as I know, in Belgium there's not a draft yet.
That's normal. That's normal.
That's all. But we don't have a draft, well, we have an informal draft, which is the German translation of the directive. The big issue will be to find an efficient and working redress mechanism. Because, especially in Austria, they want to rely on the civil courts, and you will get lost in front of civil courts in these issues, as our case showed. 13 years will kill any business model that you have in mind now and you want to execute tomorrow. And the time frame in between now and tomorrow, 13 years, is a bit long. So, that's it from my side. I hope I gave you an impression of the real obstacles, the real life experience, copyright, database protection, public sector information, dealing with the administrators and public sector body, and the outcome for a small private entity and enterprise like ours. Thank you very much.